Hi, it's the Florida Law Guy. When a defendant pleads guilty and they change their mind and they decide, oh my God, I just made a mistake, I don't want to plead guilty, I want to go to trial, is there anything they can do? Today we're going to talk about motions to withdraw your plea. If a person has entered a plea of guilty or no contest, but then changes their mind and they want to have a trial, they can file a motion to withdraw their plea of guilty. It is easier to withdraw a plea prior to sentencing than it is for the defendant who's already been sentenced by the court. Under Rule 3.170 of the Florida Rules of Criminal Procedure, the court may, at its discretion, allow a defendant to withdraw a plea upon good cause at any time prior to sentencing. Notice that the word is may, not must or shall. It is completely within the judge's discretion. Now, what is good cause? Good cause is a very subjective term, and one judge might consider a reason to be good cause, while another one might not. Again, it is completely within the judge's discretion. However, since most people are sentenced immediately after they enter a plea, the majority of people who want to withdraw their plea prior to sentencing normally request to do so within minutes of entering a plea. So in most cases, judges allow it under those circumstances. If a person is allowed to withdraw their plea, this fact can't be used against them in trial. The jury will never be told that the defendant previously pled guilty to the charge before withdrawing their plea. If the defendant's already been sentenced before filing a motion to withdraw the plea, then it's a much more difficult procedure. First of all, the motion must be filed within 30 days of sentencing. If you file it on the 31st day, it's too late. Second, there are only two reasons for being permitted to withdraw a plea after sentencing. One is that the state violated the terms of the plea bargain. This is extremely rare, and I've never personally seen a case when this has happened. But if it does happen, you can withdraw your plea. The other reason for being allowed to withdraw a plea of guilty after sentencing is if the plea was not entered freely and voluntarily. Now, most of the time when the defendant makes that allegation that the plea was not entered freely and voluntarily, the defendant normally alleges that the attorney used undue pressure on them or twisted their arm in order to get them to enter the plea. However, because when people enter a plea of guilty, there is a court reporter, the state attorney normally orders a transcript of that proceeding. Because judges are required to specifically ask defendants if their plea of guilty was being entered freely and voluntarily, and if they were satisfied with their attorney before accepting the plea, although it's not impossible, it is normally a very difficult challenge to overcome, and it's very hard for people who've already been sentenced to be allowed to withdraw their plea. Therefore, the smart thing is for people to be very cautious before pleading guilty because there may be no turning back. It's completely free, so please support my mission to help make Florida law simple for the public to understand by liking and clicking the subscribe button. The way YouTube's algorithms work, the more likes and subscriptions a channel gets, the easier it is for others to be able to find it. So by subscribing, you'll also be helping others. Thanks for watching. See you next time.